You're watching CBS 11 News at 4. Coverage you can count on.
Now at 4:30, a Texas case goes to the Supreme Court. It could have a big impact on the future of college admissions around the country. 22-year-old Abigail Fisher says she was denied acceptance by the University of Texas in Austin because she is white. Well, now the High Court is questioning UT's affirmative action plan. Attorney Thomas Brandt from Fanning Harper in Dallas joins us live here. So, Mr. Brandt, explain exactly what this court must decide in this ruling.
Yes, this case is about Abigail Fisher's rights and her rights under the 14th Amendment of the Constitution, her equal protection rights. So what the court must decide is whether or not the use of racial preferences in the admission process actually denied Abigail Fisher's rights under the 14th Amendment, her rights to equal protection of the law. So it's a question of whether or not when racial preferences were used in the process, whether her rights were violated.
Okay, and if we take this broader, then how does this affect all college students?
Well, the current college students aren't affected. Future college students may be affected by this decision. And I'll say, at UT, people who are applying to UT Austin may not be affected as much because of the top 10% rule. The top 10% rule in Texas determines the vast majority of the admissions for UT Austin. What we're really talking about, because Abigail Fisher was not within the top 10%, she was not entitled to the automatic admit. That is a neutral law that effectively achieves this diversity that is trying to be achieved. But for those systems outside of Texas or other schools who may use something different than the top 10% rule, it could have a very major effect. But it all depends on one man's opinion, and that's Justice Kennedy. He is the swing vote in this case, and whatever he says is going to determine this case. And he is one who's particularly nuanced in his thinking and his writing, so we have to watch very carefully what he says.
Okay, keeping an eye on him. As far as the 2003 ruling allowing the University of Michigan to continue using race as an admissions factor, would this then overrule that case?
It could. But as I said, Justice Kennedy, although he was in the dissent in the Grutter decision, the one you're referring to, it's more likely, the way he approaches things, it's more likely that he will find a way to distinguish Grutter rather than outright overturn it.
Okay.
More or less that he would refine the law. Grutter talked about trying to achieve a critical balance, or I'm sorry, a critical mass of minority students in your school. And I think what the opinion will likely do is try to define with more specificity how do you determine what is a critical mass, and once you've achieved it, what do you do then? How long does the racial preferences need to be kept in order to maintain that critical balance?
I think you said, used a great word, refinement. That's what we can expect to see from this court ruling.
I think so,
okay.
Yes.
All right. Thank you very much, Attorney Thomas Brandt, again, for spending some time with us today.
Thank you very much for having me.